Council of State Governments, through our National Center for Interstate Compacts, has been exploring policy solutions ranging from state-supported prescription monitoring programs all the way to the development of a prescription monitoring interstate compact to facilitate interstate data exchange. All of this work has been member-driven, and we've been tremendously pleased to be involved with it and hopefully help to find a workable solution to the problem for both states and practitioners. Today, we're scheduled to hear from two excellent speakers about several items, including the scope of the problem, some of the ways states are working to address prescription drug abuse, and the possibility of a prescription drug interstate compact, and how that might allow states to begin to share data across state lines. Before I turn it over to Senator Schmidt and Mr. Masters, I did want to go over just a couple of housekeeping items. First of all, we are using a software today called GoToWebinar. Currently, you should be viewing my screen, which has today's agenda on it. The advantage of GoToWebinar is it allows you to both listen to the presentations and also follow along with the slides as Senator Schmidt and Mr. Masters work through them. I should also note that today's session is being recorded and will be posted on CSG's website shortly following the completion of the webinar. That will allow you to listen to the remarks from both Senator Schmidt and Rick following the webinar, and also to review the slides if there's anything that you'd like to look at again. GoToWebinar also allows you to ask questions directly to the presenter. If you would like to ask a question, there are a couple different ways we can do this. First of all, there is a question box at the bottom of your GoToWebinar menu. If you would type your question in directly to that, it will then come to our staff here, and we will be able to ask the questions directly of either Senator Schmidt or Rick. The other option, if you don't like that method, is to simply send an email to my colleague here at CSG, Nathan Dickerson, and you can reach him at ndickerson@csg.org. That's NDICKERSON @csg.org. One last note, in the interest of time and making sure we give adequate time for both Vicki and Rick, we'll hold questions to the very end. With that, let me go ahead and introduce Senator Schmidt, and I will turn the floor over to her. Vicki Schmidt currently serves as a state senator for the 20th District of Kansas and is Assistant Majority Leader. Her district comprises the southwest area of Shawnee County and Topeka. She serves on the following legislative committees: Chair of the Ethics and Elections Committee, Chair, Joint Committee on Administrative Rules and Regulations, Vice Chair of the Public Health and Welfare, Vice Chair of the Committee on Health Policy Oversight, the Ways and Means Committee, and the Transportation Committee. And Senator Schmidt also chairs, or I should say co-chairs, our Health Committee at CSG. Her legislative appointments are as follows. She serves on the Kansas State Advisory Council on Aging, the Capital Area Plaza Authority, the State Employee Compensation Oversight Commission. She co-chairs the Midwestern Legislative Health and Human Services Committee out of our CSG Midwest office, and also serves on the Executive Committee of the CSG Midwest office. Senator Schmidt is a graduate of the University of Kansas with a degree in pharmacy. She is also a practicing pharmacist and has served on the Board of Pharmacy for 6 years, including 2 as president. During that time, she was also a member of the Executive Committee of the National Association of Boards of Pharmacy. Married to Michael J. Schmidt for over 36 years, they are the parents of 2 grown sons and 1 new daughter-in-law. Senator Schmidt has been tremendously helpful in our work, and so with that, I will turn the floor over to her. Thank you, Senator.
Thank you, Grady. That was a great introduction. I really appreciate that. Well, thank you. We are going to talk about prescription drug abuse today and the epidemic that it has become. Okay, next slide, I guess. The first slide that I want to talk about is just the scope of the problem. Prescription drug abuse is recognized as the nation's fastest growing drug problem, and prescription drugs are the second most commonly abused drug behind marijuana. I think the startling statistics show that nearly 1/3 of all people aged 12 and over who abuse drugs for the first time abuse prescription drugs. That's an alarming statistic to many of us in this field. In Kentucky, the rate of prescription drug abuse has doubled among men and tripled among women in the last 10 years. In Florida, estimates suggest that as many as 7 people are overdosing daily, every day, on prescription drugs. And we know that in the U.S., we consume about 95% of the hydrocodone worldwide, right here in the United States. Deaths from prescription drug overdoses are the leading cause of accidental deaths in 17 states. At the center of this epidemic are Schedule 2 through 5 pharmaceutical products, and those are the things like Lortab, hydrocodone, Demerol, Adderall, methylphenidate. While many states regulate these drugs, stricter and more uniform standards, I would say, are not probably needed. They are needed. And until that happens, we'll continue to see some of the diversion and the drugs that are used for illicit purposes. With the epidemic of the prescription drug abuse continuing to grow, the Obama administration released an ambitious plan in April of 2011 to reduce the problem. The plan aimed to curb abuse by cracking down on pill mills and pain clinics and requiring manufacturers to develop better education programs. I'm sure many of your states have seen some of this. The plan also called for each state to develop a PMP. And I want to recognize how important CSG has been in helping states develop those PMPs, those prescription monitoring programs, or sometimes they're also called prescription drug monitoring programs, PDMPs. Without CSG's help and without NAMSDO's help on model legislation, many of the states wouldn't have this opportunity and this tool to use to start this crackdown. And I know in Kansas ours has been up and running for over a year now, and the users being both prescribers, physicians, and pharmacists has been overwhelming their support of the program. So kudos to CSG for helping all of us do that. According to the National Alliance for State Drug Laws, 40 states have operational PMPs. I know some legislation, I know in Missouri, for example, they're working on that legislation this year, probably this week yet. But it takes a little while after the legislation before you get the operational PMPs. But to think that 40 of us now are operating them is really a great thing. 8 states have that enabling legislation, and hopefully they are pursuing that. You can visit this website, NAMSDO's website, and it will show you a map and tell you about all the information about those and how the states differ in those PMPs. The state PMPs just represent a tremendous first step for us. But there is still a need for interoperable system that allows for data sharing across state lines. For us, we have a major metropolitan area in Kansas City. So Kansas City, Kansas, and Kansas City, Missouri, it would be great to be able to share that information. 2 such options currently exist or could exist to ensure that interstate data sharing that we're considering. The first one is the National Association of Boards of Pharmacy, or NABP, and they have a pharmacy interconnect working right now. And the second is a prescription monitoring program compact developed by CSG. The NABP interconnect is implemented through a Memorandum of Understanding, or MOU, between the states and NABP. Each state determines who they want to share with, and the state has complete control over who has that user access with that. To date, 13 states have signed MOUs with NABP. I know that Indiana and Ohio are currently exchanging information, and I believe Virginia, Michigan, and Connecticut are now connected. There are additional 8 other states with those MOUs. So you've got those 13 states that have MOUs with NABP. And I think that some of those states, those other 8 will start to follow soon. And with that, I think Crady is going to have Mr. Masters talk about what the compact portion of this is with CSG. And thank you very much.
Thank you, Senator Schmidt. I think I speak for all of us, both at CSG and on the phone. The perspective you bring, both as a legislator and also as a practicing pharmacist, is truly hard to duplicate, and your expertise in this arena is really unparalleled. So we greatly appreciate you taking time to be here with us and to present and to share some of your thoughts. With that, let me shift gears a little bit and turn the floor over to Rick. Rick Masters is the Special Counsel for Interstate Compacts and legal consultant to the National Center for Interstate Compacts, operated by CSG in Lexington, Kentucky. He also provides legal advice and counsel to 3 national compact commissions which are affiliated with CSG. Rick received his BA from Asbury College in 1976 and his JD from the Louis Brandeis School of Law at the University of Louisville in 1979. He is formerly Assistant AG for the Commonwealth of Kentucky and has previously served as the General Counsel for CSG at our national offices in Lexington. Rick has written and spoken extensively on the subject of interstate compacts and is the principal draftsman of the Interstate Compact for Adult Offender Supervision enacted by all 50 states, the Interstate Compact for Juveniles enacted by 49 states, the Interstate Compact on Educational Opportunities for Military Children, now enacted by 40 states. Rick has also testified before numerous state legislative committees on these subjects, and in conjunction with CSG, he has consulted with the National Highway Traffic Safety Administration, the U.S. Department of Justice, and the Office of Juvenile Justice and Delinquency Prevention, as well as the U.S. Department of Defense concerning various interstate compact matters. Rick continues to be involved in consultation, research, and writing concerning interstate compacts and constitutional law. He has co-authored numerous articles concerning the law of interstate compacts, including a law review article about the Interstate Compact for Adult Offender Supervision, which was first published in the fall of 2003. Rick also co-authored the Evolving Use and Changing Role of Interstate Compacts, a Practitioner's Guide, which was published by the American Bar Association in 2007. And while Rick is a little bit too humble to admit it, that is very much the Compact Bible. So with that, let me turn the floor over to Rick, and thank you again, Rick, for joining us today.
Thank you, Crady, and I appreciate the opportunity to be with all of you today to discuss this terrific problem that our nation faces on a state-by-state basis concerning the abuse of prescription drugs, which Senator Schmidt has very cogently laid out for you. A number of alternatives exist to solve this problem on a multi-state basis, or maybe I should say attack this problem with the hope of eventually solving it on an interstate basis. And as has been mentioned already, one of the possible alternatives which has been considered, particularly under the auspices of the Council of State Governments and involving Senator Schmidt and others, has been a proposed interstate compact regarding monitoring of prescription drugs. First, it might be helpful to cover some ground which for some of you on the call may be a review, and for others who may not have participated in prior webinars with CSG or gotten other information about interstate compacts, perhaps new material, but it doesn't hurt to review or cover it for the first time, and I'll try to do that in short order concerning what is a compact and what is the significance of this instrument as compared with other means of interstate cooperation. First of all, interstate compacts are a time-tested mechanism of interstate cooperation which has been sanctioned by our federal Constitution in 1789. So it's a proven and effective tool for states to enter into contractual agreements with each other to cooperatively manage interstate problems without the necessity or without the intrusion, perhaps at times, of the central federal government to manage problems which require uniformity. And contrary to the practice of Congress when it preempts the field in an area where the Constitution allows Congress to do that, interstate compacts instead allow states to share responsibility, to share sovereignty, to create economies of scale when they enter into contracts with one another, to create uniformity and manage a problem with one voice while retaining their collective sovereignty so that they can act together to manage such problems. As stated, and we've got another slide here just reemphasizing that point, interstate compacts are not new. As I said, they go back to the beginning of our foundational document, the Constitution, in 1789, and were in fact used even before that date by the 13 original colonies to resolve boundary disputes between them. What is new about compacts, particularly from the midpoint of the 20th century through the current use of these instruments in the 21st century, has been the employment of interstate compacts to create ongoing administrative agencies to manage interstate problems such as prescription drug abuse. As stated, interstate compacts are, first of all, contractual relationships. However, the parties to these contracts are not private commercial entities or individuals, they are states. But in concept, an interstate compact is nothing less than a contract which has been statutorily embedded into the codes of each state. And so like any other contract, the first state to adopt compact legislation or to enact it is making an offer to every other state which might then enact that same legislation in substantially the same form to accept that offer and enter into a contractual relationship with each other and each subsequent state that joins. And like any other contract, the language must be sufficiently similar so that the parties have entered into a substantially consistent agreement without significant deviations from one state statutory code to another. Once enacted, as I stated at the outset, compacts are protected by the federal Constitution, not just through the compact clause, which authorizes them, but through what is called the contract clause under Article 1, Section 10, Clause 1 of the Constitution, which states that no state may impair the obligations of a contract, including a contract entered into between states for the purpose of managing an interstate problem. And as this slide mentions, although a state can't be bound by a compact to which it hasn't enacted, once enacted, it does take precedence over conflicting state statutes, and a state which has enacted a compact can't unilaterally nullify, revoke, or amend it if the compact doesn't provide a mechanism to do that. So you see that there are features, as with any other contract, which allow interstate compacts to be enforced in a meaningful way. The Supreme Court has decided numerous cases going back 2 centuries, and thankfully, I'm sure you'll be relieved to know I'm not going to cover all of them. I'm going to just call your attention to one recent case in which the Supreme Court reiterated some long-held principles about interstate compacts in a case called Alabama versus North Carolina, which concerned the interpretation and construction of the language of one of the regional low-level radioactive waste compacts. And that case is significant because it reiterates several important points, 3 of which are featured here on the slide. First, a court is not going to rewrite a compact and is not going to read absent terms into an interstate compact which aren't there because of concerns under federalism, the 10th Amendment, etc., and separation of powers concerns which would arise if a court was to try to rewrite an agreement which is a contract among sovereign states to which the legislatures have consented. Secondly, a court will respect and enforce the compact as it's written. It will not order relief inconsistent with the expressed terms of the compact. And finally, the 11th Amendment of the Constitution, which otherwise protects state government treasuries from being sued by individuals, does not bar enforcement of an interstate compact among the states that are members of it to enforce the mechanism. So it's an important recognition of the enforceability of compact agreements among the states that are members of the agreement. There are many purposes for which compacts are used, some of which we have discussed already. These could be categorized into three primary types. One would be compacts which are used to resolve boundary disputes. As I stated, since before the Constitution, the early colonies used these mechanisms to resolve the location of boundaries between colonies, and the states have continued to use compacts for that purpose. Secondly, these instruments are used to institutionalize and manage interstate issues pertaining to such things as natural resources. I frequently say, show me a river basin and I'll show you an interstate compact. When we have natural resources such as rivers, which flow among more than one state, things like fisheries, pollution, water allocation, and other aspects of legal issues that arise from those natural bodies are managed usually through the mechanism of interstate compact. And then finally, as was stated, the primary use of compacts since the mid-1950s through the present has been to create various levels of regulatory control to promote uniformity among the states in interstate matters that can't be unilaterally regulated by just one state. And we've got some examples here that are checked on the slide, everything from transportation to taxes to education to corrections to such things as prescription drugs, which bring us here today. There are approximately 200 compacts that have been formed since the Constitution was ratified in 1789. About 40 of those are inactive, but the majority are still alive and well. On average, each state is a member of at least 24 compacts, some more, some less, but as this figure reveals, these are not instruments to which state legislatures are strangers. These have been used frequently and on an ongoing basis to the level of at least 24 per state to manage many of the problems that we've already mentioned in the previous slides. One of the earliest regulatory compacts, which, as the slide says, signaled a new era in these types of compacts with the Port Authority of New York and New Jersey, which you may recognize is the campus on which the World Trade Centers were formerly located, and governs all public transportation, subways, buses, trains, ferry boats, etc., between New York and New Jersey, has a multi-billion-dollar budget and its own police force, dates back to the 1920s, and is one of the first of those types of compacts. There are other forms of multi-state cooperation, and we're certainly not here to suggest to you that for this problem or any other that an interstate compact is the only solution. Some other examples of other types of multi-state cooperation are mentioned here on the slide. One is multi-state legal actions, such as those that were utilized by the National Association of Attorneys General, where the Attorneys General, acting cooperatively, engaged in legal actions against tobacco companies to recover costs of health care and other consequences of smoking. These are very narrowly focused, obviously, and are management by court adjudication, which some would argue is only applicable in some very narrow contexts and perhaps not as widely available for other types of problems. Another approach that states use for multi-state cooperation is uniform state laws. These are promulgated by what is now known as the Uniform Law Commission, formerly the National Conference of Commissioners on Uniform State Law. These are exemplified by such things as the Uniform Reciprocal Child Support and Enforcement Act and other types of multi-jurisdictional matters that have been regulated by uniform laws. The Uniform Commercial Code is another good example of uniform laws. One of the problems, however, with uniform laws, or one of the limitations, is that, in fact, they're not always uniform. States are free with a uniform law to tweak it and change it, and in some cases have created some problems that have arisen because they have not maintained that uniformity. There is also no ongoing administration of a uniform law or any type of mechanism to actually enforce those uniform provisions across the country among the states that have adopted those acts. There are also administrative agreements, sometimes referred to as memoranda of understanding, that various agencies of state governments enter into with one another usually either through the governor's office or some executive branch agency, which typically take the form of a contractual agreement, but are not binding on the state as a compact would be, because the legislature does not enact such agreements as part of the statutory code of the particular state. Currently, I think as Senator Schmidt has suggested, this is the avenue that has been used for many states for resolving this problem in the short run with regard to prescription drug monitoring, where we have at least 13 states, I believe, which have signed MOUs with the NABP. The advantages, in summary, of using interstate compacts are that we have an enforceable means of state cooperation, of interstate cooperation. It allows states to achieve uniformity without the necessity of federal intervention. While states give up the right to act unilaterally, they retain their sovereignty to manage a problem collectively. Because when you think about it, once a problem exceeds the boundaries of a particular state, one state legislature really can't solve that problem alone anyway. And other than intervention by the federal government, the most binding and enforceable means of attacking that problem would be in the form of an interstate compact, which promotes collective sovereignty. It also provides opportunity for states to work together, in some cases with federal partners and other stakeholders, and as said, to avoid conflicts such as those that arise from federal preemption. There are disadvantages. Obviously, it is a lengthy and challenging process for states to enact an interstate compact in sufficient numbers, depending on the nature of the problem, to adequately deal with it. CSG has been quite successful in working with Senator Schmidt and other legislators and other branches of state government in not only dealing with other problems through the compact mechanism, but also educating and providing resources for legislators and other state officials to facilitate compacts where that has been decided as the alternative of choice to manage a particular problem. Another problem that arises is lack of familiarity with compacts. While most states are members of 24 compacts, not all legislators are familiar with the mechanisms. In states where there are such things as term limits, you may not have that institutional memory where there are legislators still serving that recall the details of the compact mechanism that has been used many times in the past. Certainly CSG works to try to resolve those problems and improve the knowledge base of compacts through the National Center. There is a perceived loss of individual state sovereignty when a state joins a compact. As I stated, the state does give up the right to act unilaterally, but the alternative would be for the federal government to intervene, in which case the state's sovereignty is virtually completely surrendered if the federal government has the authority under the Constitution to take it over. Finally, there is, in most of these regulatory compacts, the need to at least have a limited delegation of regulatory authority to an interstate agency. Now, while this is not particularly shocking to lawyers, judges, legislators, and others who are familiar with administrative law, sometimes there is concern that is justifiably expressed by legislatures that we not have a multi-state agency that is strictly accountable to each state, and so we have to be careful when these compacts are put together and when the legislation is drafted to make sure that there is sufficient control on that regulatory authority. But that has been another area of potential concern which can be remedied. We will go briefly through what I would call the high points of the proposed interstate compact with regard to prescription drug abuse. This has been a process in which CSG has served as a neutral convener, a facilitator, and a resource. We have not prescribed and are not necessarily prescribing that this is a solution which must be adopted or should be adopted. It's simply that it is a viable alternative open to the states and available to the states should they wish to use an interstate compact as a means of solving this problem. The goal here was to provide states with the tools necessary and sustainable to govern and enforce data exchange about prescription drugs so that it can be, the abuse of these prescriptions can be effectively monitored. It's been a state-driven solution. We have had involved in that process not only governors and staff, but legislative leadership, legislative staff, and executive agency directors that are already involved in managing this prescription drug monitoring process in the states. CSG also convened among the advisory group that put together this draft external stakeholders, national associations and groups, academic and scientific research agencies and entities, as well as federal agencies that are involved. The goals the goal here, as stated, was not to come up with a with one solution, and that or to suggest that interstate compact is the only way for a state to resolve this problem. Certainly, CSG's role as a promoter of the role of states within our federal system believes that this should be a state-driven solution, but there certainly are various alternatives available in addition to compact. The effort sought to examine the obstacles as well as the opportunities concerning data exchange and effective ways to carry that out for the purpose of attacking and managing this prescription drug crisis that we have. And the effort resulted in recommendations for a PDMP agreement. The compact itself, and again, because of the time here, I'm not going to go through in any significant detail all of the provisions of the compact, but just to call your attention to several important achievements and goals in the proposed compact draft. First and foremost, the compact seeks to preserve the rights of the member states with respect to retaining authority and autonomy over the prescription data. Certainly, states are justifiably sensitive about maintaining that control. It also provides that states may restrict or deny prescription data to a requester in another state under certain circumstances, and may provide, restrict, or deny data received from another state to a requester within that state, as well as maintaining the authority to determine which requesters are authorized to access the data. These are overriding concerns that are preserved by the compact. There are also restrictions in the proposed compact on data obtained by a member state. For instance, data is used only to provide information to an authorized requester. Data is not stored in a state's PMP database, and a state may limit under the proposed compact the categories of requesters of another member state that will receive data. Now, the compact does establish a governing body made up of representatives for each state, referred to as an interstate commission. The draft compact refers to it as the Interstate Prescription Monitoring Program Commission, which is styled as a joint agency of the member states composed of a voting representative from each member state prescription monitoring program. The Commission has responsibilities under the proposed compact to establish an executive committee and additional committees as necessary, requires that public notice be given for all Commission meetings, and that all of its activities will be open to the public. The compact does provide, as other compacts provide, for limited authority to promulgate rules for the management and exchange of this data, for enforcement of the compact, and mechanisms for dispute resolution and enforcement among the states. The compact would become effective under the draft once adopted by 6 states. And at this point, as I said, this is one of several alternatives that are available to states, which CSG has attempted to put forward, and we're happy to be able to talk about this and other solutions today on the phone with each of you. And Crady, at this point, I'm going to turn this back to you, and we're happy to answer any questions.
Thank you, Rick. Again, thank you for being here, for giving up your time and sharing your expertise. As I said earlier, Rick has been the principal drafter on a number of interstate compacts, including this particular compact. And certainly, while our time is short today, if you have any specific questions about the compact language, about how it might impact your state, about actually receiving more information about it, please send those questions to me. You have my contact information in all of the webinar invitations that you received, and either Rick or I will get back in touch with you regarding specifics. We do have a handful of questions that have already come in, and I will start with those in just a second, but I do want to note we have about 20 minutes or so for Q&A, so we're right on schedule. If you do have questions, please go ahead and submit those either into the dialog box or ask questions via email directly to Nathan Dickerson at ndickerson@csg.org. I think to begin, we've got several questions that have already come in, so let me begin with question number one. This question is for Senator Schmidt to begin. Senator, you talked at length about what states are doing in terms of prescription monitoring programs. Do you see any opportunities for partnership between the states and the federal government? I guess that question is originally asked of Senator Schmidt, but based on some of Rick's remarks as well, Rick, you might like to chime in too. So, Senator, your thoughts on that question?
I think it'll be imperative that we share information across our states. I don't really see the federal government coming in and designing a system for us to do that. I think we have a couple of ways to do that currently, and I think those will become more important. I think as more and more states develop their prescription monitoring programs, the Harold Rogers grants have been just a huge help in providing assistance to states to do that. Once everyone gets up and running, perhaps some of that money can be funneled back through the states to help pay for that connectivity. But the other thing I would say is that one of the missing pieces to most PMPs are the access to the VA information. If you have any military bases in your states and you have and then we didn't have access to that. The federal government is helping, and it sounds like we're going to make a drastic change and allow us to have their information in our PMPs. So,
Rick, I know you touched on this a little bit in your remarks. Anything you wanted to add in terms of opportunities for states and the federal government to perhaps partner in a compact or any other kind of interstate solution?
Absolutely, Craig. Certainly there is precedent among the various interstate compacts that exist for federal participation even as a member of the compact. Certainly there are cases where the federal government enjoys at least an advisory role as an ex officio or non-voting member to a number of national compact commissions. And certainly, while obviously compacts aren't the only way to attack this problem, federal participation through that mechanism is certainly justified, and there is precedent for it.
Thank you, Rick. Next question is for you, Rick. It reads as follows. My understanding of interstate compacts is that they traditionally require congressional consent before becoming active. Is that true? And would the prescription drug compact necessitate consent?
Well, sorry to sound like a lawyer, but I am one. The question is sometimes, but not all compacts, contrary to what the Constitution appears to say, are required to have congressional consent. The compact clause of the Constitution is worded in such a way that if you are not aware of the Supreme Court interpretations of it, it seems to state that all compacts require congressional consent. In fact, the literal language of the compact clause is that no state may enter into any compact or agreement without the consent of Congress. Now, the Supreme Court has interpreted those words to mean that any agreement or compact doesn't mean all. this is probably the first case in the history of grammar where any means some, not all. So the compact clause has been construed by the court to require congressional consent only to those compacts which infringe upon the authority that is granted to the central government or the Congress of the United States under the federal Constitution. If the states, by entering into a compact, are simply collectively exercising power that is reserved to them anyway and not subject to the enumerated powers of the Constitution reserved to the federal government, then no consent is necessary. Whether or not this compact would require consent could perhaps be debated, but at this point anyway, the proposed draft is not thought to be one which would require consent, since the states are exercising authority that they already have and are already engaged in to regulate prescription drug use and to monitor it, except this would be across state lines.
Thank you, Rick. The next question, and I guess this is probably for either of our two presenters, the compact idea is an interesting one, and certainly one that I think has tremendous potential for states and holds tremendous potential to reduce prescription drug abuse. That said, it's not something that will occur immediately, and I think, Rick, you alluded to that in some of your remarks. We talked a little bit about the NABP proposal. We talked a little bit about the state monitoring program. But are there other steps that you all think that state policymakers should also be considering to reduce the epidemic of prescription drug abuse? Senator Schmidt, I'll throw it to you first.
Well, I can tell you that I think people need to go, states need to go back and look at their PMP enacting legislation. I know here in Kansas we're revisiting our legislation, and probably will open that statute back up within the next 5 or 7 days to amend some things. One of the things we did in Kansas was we restricted activity. Law enforcement could only get it by subpoena, and we also restricted the PMP, both the advisory committee and the staff, to not be able to share information. And that's a can of worms you hate to open. But on the other side of it, the very first query we ran, we had one individual that saw 44 unique physicians in 30 days and had visited 12 or 14 unique pharmacies. Well, we need to be able to, I mean, if we're going to help that individual, we need to be able to get that help to them, and we need to be able to work on that. And currently we can't do that in our state. So I think, my advice is if you have a PMP in your state, you need to go back and make sure, talk to the people that are running your programs, make sure that they're doing all they can. And then I think the other piece of it is the counseling and getting individuals assistance that are having problems with addictions to these medications.
Rick, anything you wanted to add to that question?
Yeah, Grady, I think there's room here for a variety of approaches, and as the question suggests, the immediacy of the problem sort of demands, some type of action that is timely and perhaps militates against using a compact as the only way to solve this problem, and we're certainly not suggesting that that's the case. As has been stated, 13 states currently have MOU agreements with the NABP trying to tie these operational programs together, which I think the figure we've been using, Grady, is that 40 states have some type of monitoring program, and I think that's the critical issue here, how best to tie these programs to one another and to interlink or interrelate these programs to each other. Certainly an MOU is one of the ways that could be done. A compact is another way, and they don't necessarily have to be in conflict with one another, although ultimately if a compact is determined to be a solution, that would probably ultimately take precedence over other activities once sufficient number of states became members of the compact.
Thank you, Rick, and thank you, Senator Schmidt, for those well-thought-out answers. Next question, and I think this probably goes to you, Rick. Can you describe in a little bit more detail some of the key provisions of the current prescription drug compact? I know you alluded to that a little bit in some of your remarks, but could you go into a little bit more detail for the audience?
Well, I think the creation of a hub or a clearinghouse for this information is the most critical aspect of this. And so the compact focuses particularly on such things as technology and security. It requires the Commission to establish security requirements for the protection of patient privacy through rules for transmission of prescription data. It requires the Commission to establish open standards for the technology infrastructure which will be created. And obviously the technology piece of this is the most critical and the most important. And it makes the Commission responsible for the acquisition and operation of the technology infrastructure. How it would be funded is certainly another challenging aspect of this. I know there are a number of grants and such that are being used now by the states to fund these programs, and certainly the Compact Commission would be authorized to accept such grants and contractual agreements to support the Commission under appropriate conflict of interest standards, etc. It would also have a mechanism where the states could fund this in a manner that they choose and in a way that would be consistent with their fiscal concerns. But I think that the establishment of the clearinghouse is the critical piece of this. As I stated, there's what I would call compact boilerplate, which creates an interstate commission, provides for the appointment of those members of each prescription drug monitoring program to represent the state, gives that group some authority to meet together to convene and to form the regulations and policies for the exchange and administration of this data in a way that is consistent with how other compacts do it.
Okay. Next question, and I think this probably goes to Senator Schmidt. It comes from one of our viewers out in California. Senator, in terms of some kind of best guess for a timeline of when you think data can really begin to be shared across state lines and on a large scale for analysis and for review, any clue from your perspective how long that might take?
Well, NABP has estimated that in 2012 they'll have 20 states up and running, sharing through the interconnect. I think that's a little bit optimistic, but I think that that could occur. The problem is linking states that are geographically next to each other. I mean, I'd love to get Virginia's data in Kansas, but I'm not sure that's so helpful to me. So that it's depending on where those 20 states are and the proximity that they are to. But if we keep progressing with it and with the MOUs through the interconnect, I think it could be in the next maybe 24 months to 36 months once they, because they have the basic infrastructure in place. NABP has funding for 5 years through their foundation currently, and I know that's also been expressed as a concern. Well, what happens after the 5 years? And I don't have the answer to that, but the compact is set up in a similar way in that the compact can accept grants and funding sources just like NABP is.
Thank you, Senator Schmidt. We also have a comment here from Massachusetts, not so much of a question, but just a general comment. It reads as follows: the Alliance of States with Prescription Monitoring Programs, and I should note that they were very instrumental in both our initial advisory work and also helping us draft the Interstate Compact language that Rick spoke about, has been working on interstate data sharing with the help of the IGES Institute since 2005. The Alliance and IGES proceeded work on the Compact and the NABP Interconnect, and the Alliance Hub is operational. If any states are interested in assistance, they can contact the Technical and Training Assistance Center of the Alliance by visiting pmpalliance.org. And that comes, like I said, from one of our listeners in Massachusetts. With that, I think we've had several very, very good questions and a lot of really, really insightful discussion and conversation from Senator Schmidt and Mr. Masters. I've got about 1:25 by my watch. I don't think, Nathan, that we have had any more questions, so let me thank everyone for taking time out of your schedules to join us. Let me once again publicly thank both Vicki and Rick for being here.